So thank you for having me. Thank you again for the opportunity to present and to be part of this grant program. It's been really interesting project for me. I am and have been a privacy and surveillance scholar for a number of years, although most of my work has been focused on police surveillance, Fourth Amendment issues, those sorts of things, and less so on sort of consumer privacy. But I started to get a lot more interested in this and wanted to use this project as a way to shift some of my work on privacy into the consumer privacy space. And so part of what motivated my application for the project here was this idea that, right, we've had data protection law in Europe and a variety of other countries around the world for some time. There's been a lot of resistance. We've had not much success in terms of getting sort of broad, non-sectoral or comprehensive, however you want to frame it, privacy laws in the United States. But in the last few years, we've started to see a lot more interest. A lot of legislatures, including the federal Congress, but also in state houses around the country, have been considering and now even adopting consumer data privacy laws as sort of the broader non-sectoral types of privacy protection. And so at the moment, we have California, Virginia, and Colorado have adopted these laws, and Utah has approved one that's just on the governor's desk this week or next week. So we have, and there are dozens of states in the last couple of years that have talked about this. And so part of what's motivating this project is to gain an understanding of the current state of consumer data privacy law here in Oregon. So what sorts of consumer privacy protections exist here? And partly for me, this is something I was interested in as well, as sort of being a little bit newer to Oregon, is trying to get up to speed on what was happening here, but then to relate that to broader movements that we're seeing in privacy and the commercial privacy law space around the country and elsewhere. And the Oregon Attorney General's office in 2019 initiated a task force to start investigating the development of broad consumer data privacy legislation here in Oregon. Some of that part of that work has gotten a bit derailed by sort of shifted focus because of the pandemic, but there's still efforts moving there, moving forward there. And so part of the focus of the work is thinking about what's good in these existing approaches to protecting consumer privacy more broadly, and what might we recommend that the Oregon legislature and others who are engaged in this issue here in Oregon consider. So again, just a set of research questions here, and I won't spend too much time on these, but we can come back to it. I can discuss them if you have questions. But what do these laws cover? What's their scope? What rights and obligations and so forth do they cover? How are these sort of so-called comprehensive or non-sectoral privacy laws moving us beyond what we already have in existing law, whether it's consumer protection law or privacy law and so forth at the state level? And then really, and this is something that's come out of our interviews with experts at this point, is really thinking about whether this broad, non-sectoral, broad privacy law approach is really what's best, or whether expanding our sectoral approach to privacy protection here would serve better ends and be more targeted. So I've been working with, and I meant their names were on the first slide, I should have mentioned there. I've been working with two graduate students on this project. Hugh Patterson is a master's student in the nonprofit management program here on campus at the University of Oregon, and Young-Eun Kim is a doctoral student here in the School of Journalism and Communication. So we've been working together since the fall on this project, and it involves legal research and analysis, but also interviews with data privacy experts. Those are both ongoing at the moment, so we're in the midst of both doing the research and analysis as well as interviews. And I have some early findings and things I can talk about today. A lot more will happen in the coming couple of months. We're also qualitatively coding the legislation as well as the interviews that we get in order to drive broader themes and ideas that are emerging here. So some of the initial findings, and again, these are initial things potentially would change. We've seen, these broad privacy laws, sort of like GDPR light, they've often been called, sort of arriving in a number of states, as I mentioned, California, Virginia, Colorado, and now Utah, with a number of others potentially passing and moving forward this legislative session around the country. I just wanted to highlight some of the laws that Oregon already has, right? There are a number of laws, and this is a non-inclusive list, but there are very statutory and tort-based privacy protections. There's statutory protections against things like hidden cameras, wiretapping and eavesdropping, misleading business practices, personal health data, student data breach notification, information security regulations, and so forth, right? So there's a broad range of laws that are already in place in Oregon and in many other states that are also adopting these broad laws as well. So part of the motivation here is to figure out what's new, and is this new approach that we're seeing around the country doing something that's worth modeling our efforts here on, or should we do something else? Some of the issues that come up here are issues that have even been involved in discussions about the GDPR in Europe for a long time, and data protection law in Europe, right? So the GDPR didn't start data protection in Europe. They've had a data protection directive since the mid-90s. The GDPR sort of expanded and codified that in regulation, but data protection law is something that's been around for quite some time outside the United States. One of the concerns is that these laws try to do a lot of things. They try to be both privacy laws, consumer protection laws, and there's many ways they get their fingers into questions of administrative law and other areas as well. So they're very broad, and they cast a wide net. There's also been a lot of discussion, and it's come out of some of our interviews as well, as to, so what is the purpose, right? So what is the purpose of data protection law? Is it to protect consumers, to create something like a civil or human right to privacy, to sort of codify that? Or is it to essentially work as a regulatory instrument to codify and sort of streamline business practices, right? So that businesses have a sense of what they can and can't do. And many laws, including the GDPR, have been criticized because they try to do both, but they are in many respects aimed at facilitating data flows and data transfers and keeping the data market alive and well, even though they do offer a number of protections, right? So there's a balance between sort of business interests in terms of what businesses do with data, how they process it, what they use it for, and so forth, and then conceptions of privacy. What is privacy? How are we protecting it, right? As something like more like a civil right, a human right, or something that is a bit more limited, as we often see in US privacy law. So I wanted to just share a couple of things from the range of these laws, or so the Virginia, Colorado, California laws, and so forth. But this is a definition for personal information or personal data that was contained in the Virginia Consumer Data Protection Act that was adopted last year. And this tracks closely with the others in many respects. California's is a little bit different, but this tracks the GDPR to a significant extent as well. And so personal data is any information that's linked or reasonably linkable to an identified or identifiable natural person. Personal data does not include de-identified data or publicly available information. So the fact that it's about something about related to an individual or an identifiable individual who may not be identified, directly, but may be identified when you combine other pieces of information as well. And so there's a lot of discussion in the literature about, well, is all data personal, right? Is essentially deal with everything. And at what point is de-identified data actually potentially identifiable if it's being combined with other information, right? And so there's some problems potentially with the ways in which we're defining these things. And I mentioned this particular definition because often these laws, the rights and obligations are triggered by the processing of personal data or doing something with data that meets this definition. Some of these laws have a variety of sort of subtypes: biometric data, genetic data, location data, and so forth, right? That are sort of separately defined subsets of personal data or personal information. If we think about what the acts mean in terms of what an identifiable natural person is, we see similar definitions here, and we see a lot of copying and borrowing across this legislation now. We're seeing what's now been called the Virginia model adopted in a lot of proposals around the country, where the Virginia law is really serving as sort of a template for these other laws as they're adopted, rather than California, even though California came first. But we can see again that this is quite broad. What do this is just to highlight some of the rights that these new broad privacy laws provide. And many of these are sort of reflected in the GDPR as well, and some of them look a little bit different in some of the laws here in the States, but most of this is very similar. Rights to access the data that's held about you, to know which company. You can ask a company to tell you what information they have, what they've done with that data, who they've sold it to, and so forth. The right to rectify or to correct false information or that a company might hold about you. The right to ask for information about you to be deleted. The right to opt out of future sale of your data. the right to have your data portable, so in a format that you can port it from one system to another, right, that you can read it. The GDPR includes language about automated rights against automated decision making, which also links to the AI regulation in Europe, and I'll sort of mention that briefly at the end again. Some of these discussions have to do, and some of the more contentious discussions in these debates about what should be included here, or whether these should be opt-out or opt-in situations, right? Whether users have to essentially opt in to allow their data to be sold with a sort of default that it can't be collected and used and so forth without explicit consent or something like that, versus whether they're all opted in and have the opportunity to get out later. And that's typically the way these laws have been drafted. Another thing that's been interesting is to look at sort of whether there's a private right of action, whether an individual or a set of individuals in class action litigation may actually be able to enforce these rights, or whether it's been relegated to state attorneys general, for example. And that's typically what we see in most of these cases, is that there's no private right of action, and that it's subject, any enforcement is subject to the Attorney General's office taking steps to enforce those rights. There's also another bunch of interesting limitations and exceptions. This is only one of quite a few, but most of these laws don't have anything to do with health information that would be as defined under HIPAA. Typically, they refer to HIPAA for definitions about health data, health information, but other types of health-related HIPAA related information and other types of health records don't fall under this it's often called comprehensive privacy laws, right? But it's clear when we start to look at the exceptions that that's really a misnomer, and so started to use the term non-sectoral. In our interviews with data privacy experts, and at the moment, most of these have all been generally sort of privacy law academics, law professors and others, although we will be expanding that to look at other types of experts in the space as well. And it has been a little bit surprising to see that so far, despite whether they're sort of very pro-privacy or very much more sort of pro-business in their perspective on privacy and data privacy, there's a consensus that these broad consumer data privacy laws are not really worth the cost, or they're not really doing what we want them to be, or what many people want them to be doing. And often the question is, well, what is privacy? What are we actually doing here? Is this actually about protecting privacy? And I know I am running short on time, just a couple of minutes. I'll hope to end up in a couple of minutes, but I wanted to share a couple of things that some of our interviewees have mentioned. One is an internet law expert, internet law generalist, essentially criticized the sort of one-size-fits-all approach of these laws, right? Trying to tackle a broad range of questions with a really broad law that may not be specifically targeted well enough or very clearly in a number of particular cases, right? So if there's particular types of information-related harms or data-related harms that we're concerned about protecting, maybe we ought to go ahead and protect those very much more directly with a more specific law, rather than taking the sort of one-size-fits-all approach. We have others that say things like this, and we heard this a number of times at this point, right? That these laws are really seen as largely going to be ineffectual, sort of retaining the status quo, providing businesses, essentially doing more to provide businesses with a sort of common set of standards that they have to refer to, particularly as these laws start to look homogenous across states, or rather than actually doing much to protect privacy. There's an interesting bit from, we heard about one of the provisions that one of our interviewees was concerned about in terms of Virginia law, which actually allows businesses to charge consumers higher prices if they opt out of it and actually exercise their rights, right? So if they don't allow them to harvest their data, they can actually charge them more, and it's specifically put into the statute, right? So we have a privacy law that's sort of saying that, well, if people exercise their rights, go ahead and charge them more money, right? Because they're not giving you their data. And that's an interesting bit. And so one of the things, this is sort of highlights the theme we've seen in these interviews, which was not exactly what I expected to hear. And that's that, one of our privacy law experts said, right, it's not like the civil rights community as a whole is thrilled about these statutes. They're not. There's some good to them that they often find, and some organizations are a bit more positive than others, and there's some difference of opinion here in the civil rights and sort of data privacy community. But generally, it seems the consensus is that these are not really as exciting and as positive as they have been made out to be in many circles. So to conclude, one of the things that we're considering here is, again, this focus on whether we might consider more targeted forms of interventions rather than the broad blanket, recommending broad blanket privacy, data privacy protections. And then we have some examples here to draw from. We have some examples that focus on sort of regulating things like targeted advertising, right, being subject of decisions that are made in a purely automated way based on data analysis and AI, biometric and facial recognition bans in a variety of places around the country, particular laws around genetic privacy, location privacy, and so forth. And I think that part of what we're grappling with here is trying to understand what are the sorts of harms that are really at play in terms of what ought to be addressed by these sorts of laws. Are these broad blanket laws accomplishing those goals, or would more targeted interventions have better merit? And so I just want to talk about a couple of alternatives, not necessarily something we're recommending at this point, but something we're considering. This is a text from the Banning Surveillance Advertising Act, which is now currently been proposed in Congress, that would essentially target and restrict the ability of advertisers to use data to target ads to individuals, right? So that's a very much more targeted piece. It's not, all of it is not reliant particularly on personal data or personal information, rather it's about targeting, which brings into the conversation questions about sort of groups and categories rather than just individual personal data. And another example, and this is a slide from McKinsey & Company, but this is looking at the AI regulation proposed in Europe, which is essentially setting standards and rules about automated decision-making and the use of artificial intelligence to make decisions that might impact people. So the AI regulation system in Europe sort of combined, and it looks in 3 different buckets of unacceptable risk, high risk, and limited or minimal risk AI systems, and regulates each of those differently. And so these are just a couple of alternative approaches to sort of broad blanket data privacy protections